Yeah, so we will start with maintenance. Hello? Hello?
Hello, ma'am.
Yeah, so maintenance in general meaning is keeping something in good condition. Means you are maintaining that regularly. Maintenance in legal terms means money or alimony. Please underline. That someone pay regularly to a former wife, husband or partner, especially when they have children together. It is the duty of every person to maintain his wife, children and aged parents. Please underline. It is the duty of every person to maintain his wife, children and aged parents who are unable to live on their own. Next is order for maintenance of wife, children and parents. So this is the main segment of this section. So section 144 of bnss deals with order of maintenance of wife, children and parents. In this section it is given that the names of the parties who are entitled to get maintenance, essential ingredients to claim maintenance and get the maintenance order of the first class magistrate. So this section provides with the persons who are entitled, names of the persons who are entitled to get maintenance, that are 3 persons: wife, children and aged parents, old parents. Okay. In the case of Muhammad Ahmad Khan versus Sahab Banu Begum, the Supreme Court delivered a judgment favoring maintenance given to an aggrieved divorced Muslim woman. Please underline. Aggrieved divorced Muslim women. Now, who can claim and get maintenance? So, section 144 deal with order for maintenance of wife, children and parents. So, according to section 441 subclause 1, the following persons can claim maintenance: wife from husband, legitimate or illegitimate child from his father, legitimate or illegitimate minor child from his father or mother from their sons or daughters. So these are the criteria under which the person can claim maintenance. Now first we will look into wife. So in the case of Chanmunia versus Virender Singh, the Supreme Court has defined wife, and it includes even those cases where a man and woman has been living together as husband and wife for a reasonably longer period of time. Strict proof of marriage should not be a precondition of maintenance under section 125. Now it is 144 of bnss. Okay, so it should not be strictly taken. If a person is if a man and woman is living together for a longer period of time as husband and wife, they are treated as husband and wife for the claim of maintenance. Now in the case of Srimati Yamuna Bai Anantrao Adhav versus Ramantrayo Sivram Adhav, so the Supreme Court held that the marriage of a woman in accordance with the Hindu rites with a man having a living spouse is completely nullity in the eye of law, and she is not entitled to any benefits under this section. For example, if a man is already married and second time he is married following all the Hindu marriage condition, all Saptapadi, 18 years condition, all they are following, but then also she will not be entitled to any maintenance because she is second wife. Okay. Hello?
Hello, ma'am. Yes, ma'am.
Yeah. In case of Siraj Muhammad Khan Jagmokatan Kam versus Hazifnusha Yasi Khan, the Supreme Court held that the maintenance can be allowed to wife when the husband is impotent. Please underline. So if the husband is impotent, then also maintenance can be allowed. So a wife can get maintenance from the husband in the following condition: she is divorced by her husband, she has obtained divorce from her husband and she has not remarried. If she has remarried, then she will not receive any maintenance thereafter. Okay. Next, very important condition, please underline: she is not able to maintain herself. For example, if the husband is earning 10,000 rupees monthly and the wife is earning 20,000 rupees monthly. In that case, the maintenance should not be given because she is earning more than her husband and she is able to maintain herself. Okay. Note: Muslim wife can also claim maintenance under BNSS, though they have their separate act. A wife cannot claim and get maintenance from the husband under following conditions: if the wife is living in adultery, if the wife refuses to live with the husband without any valid reason, if she is living separately by the mutual consent. So in all those cases, maintenance may not be granted. Now, at essential conditions for granting maintenance. So there are some essential conditions which are to be fulfilled for claiming or granting maintenance. So first is sufficient reason for maintenance are available. Second is neglect or refusal to maintain after demand for maintenance. The person claiming maintenance must be able to maintain must be unable to maintain himself or herself. The quantum of maintenance depend upon the standard of living. Please underline. So the quantum of maintenance will always depend upon the standard of living. How? For example, before your husband is earning 10,000, in 10,000 only you will be able to live properly. But now when you are filing a case for maintenance, you are asking 20,000 from him. So this is not possible. You will only be entitled to get 2,000 or 3,000 rupees as your maintenance. So any allowance for the maintenance or interim maintenance and expense of the proceeding shall be payable from the date of the order, or if so ordered from the date of the application of maintenance. So from the date of you have filed the case for maintenance, from that day only the order for maintenance will be made. Now, if any person order failed without any sufficient cause to comply with the order, and such magistrate may for every breach of order issue a warrant for levying the amount due in a manner provided for levying fine, and may sentence such person for whole or part of each month allowances for maintenance or interim maintenance and expenses of the proceeding, as the case may be, remaining unpaid after the execution of warrant to imprisonment for a term which may extend to 1 year or until payment if sooner is made, provided that no warrant shall be issued for the recovery of amount due under this section unless an application to be made to the court to levy such amount within a period of 1 month from the date on which it became due. Provided further that if such person offers to maintain his wife on condition of her living with him, and she refuses to live, please underline, and she refuses to live with him, such magistrate may consider any ground of refusal stated by her and may make an order under this section. Notwithstanding such offer, if he is satisfied that there is a just ground for doing so, these are explanations. Now come to point number 4. No wife shall be entitled to receive any allowances for maintenance or interim maintenance and expenses of the proceeding from her husband under this section if she is living in adultery. Please underline the word if she is living in adultery, or without any sufficient reason she refuses to live with her husband and now living separately by mutual consent. So under section 145 provides for the procedure of maintenance. So under procedure of maintenance, so proceeding where 145 may be taken in the following district. So 145 proceeding will be taken in the following district: where the person resides, or where he or his wife resides, or where he last resided with his wife or mother or an illegitimate child. Evidence to be given in the presence of a person against whom maintenance is to be ordered. If a person is wrongfully avoiding summons, then ex parte evidence is taken in that case. Now, alteration of allowances. Alteration of allowances means change in allowances. For example, if the court has ordered 5,000 rupees per month, but you want to change it to 10,000 rupees per month. So on proof of a change in circumstances of any person receiving under this section 144A a monthly allowances for maintenance or an interim maintenance, or an order under the same section to pay a monthly allowance for the maintenance or interim maintenance to his wife, children, father, mother, as the case may be, The magistrate, please underline, the magistrate may make such alteration as it thinks fit in the allowances for the maintenance or the interim maintenance as the case may be. For example, in the year of 2010, the order was for maintenance of 100,000 rupees. But now the situation has changed. In 1000 rupees, nothing will happen. So in that case, the maintenance amount can be enhanced or altered. Okay. So where it appears to the judicial magistrate that in compensation of any decision of a competent court, any order under section 144 should be cancelled or varied. He can cancel the order as the case may be or vary the same accordingly. Now, enforcement of order of maintenance. So 147 deals with the enforcement of order of maintenance. So according to this section, the following are the conditions for enforcement of order of maintenance. First is copy of order under section 144 is to be given to the person free of cost in whose favor the decision is made, whether it is children or whether it is old person or whether it is wife. In case of order in favor of the children, the copy of the order must be given to the guardian of that person. So if the magistrate has given an order under section 125, that is 144, then any magistrate in India can enforce the order where the person lives who has to give maintenance. The magistrate has to satisfy two conditions before enforcement: identity of the parties and proof of non-payment of allowances. Okay, any doubt?